my name is Dominish and I'm a lawyer in the Litigation and Dispute Resolution Group here at McCabe Curwood. Anytime directors' duties are considered by the High Court, commercial lawyers and their clients sit up and take notice. This is exactly what happened in the recent decision from the High Court in ASIC and Lewski. This decision concerned limitation periods, and specifically, when do they start ticking? The case concerned a company, Australian Property Custodian Holdings Limited, which created and managed a unit trust which was in the business of retirement villages. In 2006, the trustee company was in the process of moving towards listing on the ASIC. At the time, the trust had gross assets of over $500 million and net assets of over $200 million. The constitution of the company allowed for it to amend the trust deed, so long as the amendments complied with the Corporations Act and didn't introduce a benefit to the trustee company. The directors of the company wanted to make an amendment to the trust deed to create a number of fees that would be payable from the trust to the company upon listing with the ASIC. These fees were to be based on the gross assets of the company. No corresponding benefit was proposed to be introduced along with these fees. At a board meeting in July 2006, the directors approved a resolution to introduce these fees. And then at a board meeting a month later, in August 2006, they approved a resolution to lodge a new trust deed for the company. A year later, the trust was listed on the ASIC, and the company received its listing fee of approximately $33 million. ASIC investigated and brought proceedings against the directors for breaching their duties. This included a breach of failing to act in the best interests of the members of the trust, failing to comply with the trust constitution, and making improper use of their position. The problem was, by the time ASIC commenced the proceedings, over 6 years had passed since the first meeting, which is the limitation period length, but 6 years had not passed since the second meeting in August 2006. Therefore, ASIC had to plead that the vote to pass the resolution to introduce the fees wasn't the breach, rather it was the vote to lodge the documents. The matter made its way through the federal courts, and there was different views at each stage. At first instance, the federal court found that the first vote had to be invalid, as it benefited the company and the Constitution prevented that. Accordingly, the second vote to lodge the documents must also be invalid, as you can't give effect to something that was a breach of duty. Accordingly, the federal court found for ASIC. On appeal, the full court of the federal court went the other way. They agreed that the first vote was invalid, but the amendments had interim validity until ASIC set them aside, assuming that ASIC ever caught on. The second vote was essentially just a benign vote to agree to lodge the documents, and they were valid until ASIC said that they weren't. This went to the High Court, which unanimously said no. They agreed that the first vote had to be invalid, and they also said that to give an invalid amendment interim validity would be going against the very purpose and structure of the Corporations Act. As there was no interim validity, the High Court held the decision to lodge the documents must also be invalid, which would form the basis of a breach of duties. Accordingly, ASIC filed their proceedings against the directors just in time. This decision makes it clear that a resolution of directors that does nothing more than formalise an earlier resolution that is also a breach of duty is in itself a breach. That is to say, formalising an invalid resolution is also a breach of duties. This may sound like an academic distinction, but when limitation periods end between these two dates, it can make all the difference. McCabe Curwood has experience in advising its clients on a wide range of Corporations Act disputes, including disputes concerning directors' duties and the rights of shareholders. Get in touch with our Litigation and Dispute Resolution Group if you think that these laws apply to you.